Did you know that just one poorly drafted, kind of ambiguous word in a legal clause can literally cost millions of dollars in litigation? Crazy, right? Well, welcome to this explainer. I am so excited to guide you through this material today because we are going to completely demystify the world of legal drafting. Whether you're a law student, a junior lawyer, a compliance professional, or honestly just someone fascinated by how the wheels of commerce actually turn, you are absolutely in the right place. We're going to explore the essential documents every legal professional must know, and in the process, we're going to completely shift your perspective on what a legal document truly is. Because legal drafting, it's really the art of converting abstract legal rights and obligations into clear, precise written language to manage risk. So, let's jump right into it.
Okay, let's kick things off with a massive paradigm shift. There's this fantastic quote from our source material on insurance and contract law, and it says, "People often use the word contract to refer to the writing, but the piece of paper is not a contract. It is a memorialization." Think about that for a second. A contract is actually the promise, or the set of promises, that the law will enforce. That invisible, totally intangible agreement, that is the actual contract. The piece of paper you're holding in your hand is, at best, just evidence of it. It's a memorialization of a promise. Drafting is simply how we capture that invisible ghost and pin it down on paper so the courts can actually see it.
So why is the physical act of taking a pen and signing a document so absolutely crucial? Well, it's because under rules like the Statute of Frauds, which really highlights contract law's preference for formality, certain agreements just have to be in writing. We're talking about things like the sale of goods over a certain dollar amount or real estate transfers. They have to be in writing and signed by the party resisting enforcement. That signature formally binds the parties, proves their consent, and makes those promises legally enforceable in a court of law. It brings home the seriousness of what they're doing. It's kind of like when kids say, "cross my heart," but for adults with real legal consequences.
All right, let's move into part 1, Anatomy of a Contract.
Now that we understand the philosophical difference between the agreement itself and the piece of paper, let's talk about how we actually build these vital agreements. At its core, contract law dictates which of our everyday agreements are actually worthy of legal enforcement. I mean, we make promises all the time, right? From casually agreeing to meet a friend for dinner to massive multi-million-dollar corporate deals. Contract law is the system that decides which of those promises the power of the state will actually stand behind. It requires an agreement that affects or creates legal relationships between two or more people, involving at least one promise and mutual consideration.
For any contract to actually hold up, you've got to carefully draft 7 specific elements into existence. First, you need an offer and acceptance, a true meeting of the minds. You need consideration, meaning both sides have to receive some kind of measurable benefit. You need legality. You obviously can't enforce a contract to do something illegal. You need capacity, so adults of sound mind. You need true consent, completely free of any trickery. And as we just talked about, for certain deals, you need it in writing. When you sit down to draft an employment agreement, a service agreement, or a sale and purchase agreement, your job is meticulously ensuring these 7 elements are all present.
Let's look at how this plays out in the real world with something called an adhesion contract. This is a boilerplate agreement written entirely by one party and offered on a strict take-it-or-leave-it basis. The crucial takeaway here is that drafting creates incredible power dynamics. By the mid-20th century, businesses realized they could use fine print to totally alter the legal landscape, like disclaiming liability for product defects. Now, adhesion contracts are absolutely essential for modern efficiency. I mean, imagine if Apple had to sit down and negotiate the terms of service with every single iPhone buyer. No way. But they perfectly illustrate how the party holding the pen, well, they hold the power.
As we look at the essential documents every legal professional has to know, it really helps to understand that legal drafting is basically split into 2 massive hemispheres. On one side, we have non-contentious drafting. This is the architecture of deals, things like leases, wills, partnership agreements, and corporate bylaws. It's all about defining relationships to avoid disputes down the line. On the flip side, we have contentious drafting. These are the battles. When those deals fall apart, we move into the litigation documents like statements of case, defenses, and affidavits.
Which brings us nicely to part 2, deals, also known as non-contentious drafting. Think of non-contentious drafting as preventive writing. Just like preventive medicine, the entire goal here is to keep your client totally healthy and out of the courtroom entirely. A perfect example of this, and an incredibly common essential document, is the non-disclosure agreement, or NDA. This is a legally binding contract where a person or business formally promises to treat specific information as a trade secret. Imagine a startup sharing its proprietary tech with potential investors. That NDA governs the relationship and protects their most valuable assets before a dispute ever even happens. It sets the boundaries crystal clear, right from day one. Moving a bit further into the corporate world, non-contentious drafting includes the vital minute book, which records official actions like board and shareholder resolutions. Now, you might be thinking, ugh, keeping minute books sounds like boring administrative work. Actually, scratch that. It is absolutely critical. Our sources highlight this fascinating cautionary tale. A company seeking a bank loan couldn't find its minute books. Because they literally couldn't reauthorize prior deeds, they had to merge into a newly created corporation just to get a fresh set of records. They ended up spending 10% of their loan principal just to fix that one mistake. Good drafting and record keeping literally saves companies.
But what happens when that preventative writing fails? That brings us to Part 3, Battles. Contentious drafting.
When a contract is breached, or someone gets hurt, lawyers have to draft statements of case. These are the highly formal documents in civil litigation that set out the essential facts and the legal points of a dispute. If you're the claimant, you draft a statement of claim. If you're defending, you draft a defense. These documents are absolutely vital because they tell the judge exactly what the case is about, and they prevent either side from being ambushed to trial by defining exactly what facts are in dispute. There are no surprises allowed here.
Take a real-world statement of claim from the Solomon Islands, for example. You can immediately see the architecture of contentious drafting at play. Notice how incredibly methodical it is. The drafter identifies the precise parties, the plaintiff and the defendants. Then, in numbered paragraphs, they lay out the specific material facts. They aren't writing a novel here. They're stating that, on a specific date, a specific vehicle driven by the first defendant mounted the verge and hit the plaintiff. They then list the very specific particulars of negligence, like driving in an excessive speed. It is surgical in its precision.
Moving toward the end of a document like that, the drafting shifts heavily to the consequences. The drafter meticulously calculates the special damages. We're talking loss of earnings down to the exact dollar, the cost of a hospital bed at $50 a night, traveling expenses, the whole shebang. Finally, they clearly state the exact relief the claimant is demanding from the court: damages, interest, and costs. If a single material fact is left out here, the pleading is defective, and a judge might just strike it out entirely. Accuracy is literally everything. Okay, let's wrap this up with Part 4, the golden rules of legal drafting.
So whether you're drafting a massive corporate merger or a local court claim, how do you actually ensure you get it right? Producing a solid legal document means moving through these 4 deliberate stages of refinement. You always start with an outline in a rough form. Then you aggressively check the law and the facts and amend that draft. Third, you polish the language for absolute clarity. And finally, you do your final checks, knowing full well the first draft is rarely ever perfect. Good drafting is really just relentless, disciplined editing.
And when you finally hit that polishing stage, you have to ruthlessly de-jargon your writing. Look at this comparison. Lawyers often string together archaic synonyms out of pure habit, usually just copying them from old precedents. Writing alter, amend, modify, vary, or revoke adds absolutely zero legal protection compared to just writing the word amend. This is a huge takeaway for us today. Successful legal drafting depends on using simple words in their ordinary, natural meaning. Please just use plain English.
Why is plain English so incredibly important? Well, because of a terrifying little concept called the rule of construction. If a contract provision is ambiguous and 2 parties offer a reasonable interpretation of it, the courts will almost always interpret it against the party who drafted the contract. The side that prepared the document bears a special burden. This is actually designed to protect people from the dangers of form contracts they couldn't negotiate. So poor phrasing will literally be used as a weapon against you in court.
Which leaves us with a pretty provocative thought to end on. In a profession built entirely on words, where a single ambiguous phrase can cost millions of dollars, are we communicating clearly, or are we just hoping our paper shields hold up under pressure? I really hope this explainer has given you the tools to look at legal documents with a much sharper eye. Whether it's an NDA, a lease agreement, or a statement of claim, precision is your ultimate protection. Thanks so much for joining me on this journey. Take a second today to think about the documents you interact with daily. Are they as clear as they need to be? If you enjoyed this breakdown, make sure to like, subscribe, and definitely comment below with the legal document you want us to explain next. See you next time.